based on the assumption that the constituent power cannot be brought within the framework of the Constitution. The proposition that an unlimited amending authority cannot make any basic change, and that the basic change can be made only by a revolution, is something extra-legal and court can countenance. Under the Indian Constitution, the original sovereign, the people, create, by the amending clause of the Constitution, a lesser sovereign, almost coextensive in power with itself. It might be open to the amending body to amend Article 368 itself and provide for referendum or any other method for ascertaining the will of the people in the matter of amendment of fundamental rights or any other provision of the Constitution. If the basic and essential features of the Constitution can be changed only by the people and not by a constitutional authority like the amending body, was it open to the amending body? Or would it be open to the amending body today to amend Article 368 in such a way as to invest the people with that power to be exercised by referendum or any oddly or popular device? P. 791 to 796, McCulloch v. Maryland, 1819, 4 Wheat 316, State of West Bengal, Union of India, 1961, ISCR 371, 396, 398, Chi Eolum, 30 days. Gidergia, 1793, 2 Dallas 419, 470, 471, Huth v. Clarks, 1890, 25, QBD 391, 395, Dodge Woolsey, 1856, 18 Howe 331, 348, and Cohen's v. Virginia, 6 Wheat, 19 U.S., 264, 381 referred to. The preamble is part of the Constitution. That being so, there no valid reason why the preamble cannot be amended. The broad concepts of justico-social, economic and political, equality and liberty thrown large upon the canvas of the preamble as eternal verities are mere moral adjudication, with only that content which each generation must pour into them anew in the light of its own experience. An independent judiciary cannot seek to fill them from its own bosom. If it were to do so, in the end it will owe ass to be independent. For a country struggling to build up a social order for freeing its teeming millions from the yoke of poverty and destitution, the preamble cannot afford any due to the priority value of these concepts inter se. And for McKinney, the experiment for building up the social order which the dominant of the community desires, these Delphic concepts can offer no sole avenue in respect of their priority value as among themselves. They offer no guide in what proportion should each of them contribute or which of them did suffer subordination or enjoy dominance in that social order. How then in one of them operate as implied limitation upon the power of amendsical WBCA li objectively? Amendment is to give priority value to the Otbil of Etbil. JIP 796, 2. L.E.J. Betubari case, 1960, 3 SCR 250, 281, 282 AR to 110FO VD full 6, Y204206, US 1821 referred to, the theory of implied limitation propounded might be, had it as an interpretation of the Constitution depending, oil and N placal day, which is formed on vague, India duimtion of the L period of the, whenever the question of unfed limiton upon the power of, was raised, courts have not countenanced the contention. There is no. To think that the word amendment was used in any narrow 9 C in Article 1L, and that the power to amend UNIQ, that article was in N1 W1 Limi, there is power the fact that it might be obusik L is 110 ground FM Kuain Jitty with TB 111 I Nilan, that if E T Inel I Fleal Tal 14 such a way as to take away or abridge them to vest in Parliament. RT Wewire Kesavananda Matthew J. 63. Being about catastrophic consciousness has an air of unreality when toasted. In the light of what has happened between 1951, when SNLC, Ari Prasajay's case recognized the power of the Parliament to amend the fundamental rights, and 1967, BCN, the Golroth case was decided. It should be remembered that Parliament, when it exercises its power to amend fundamental rights, is as much the guardian of the liberties of the people as the courts 799-8014, Rhode Island v. Palmer, 253 U.S. 3 Mafty, explained Leeser v. Garnettle, 258 U.S. 130, U.S. v. Sprague, 262 U.S. 706, Scheiderman W. US 320, US 118, 137, 145, US v. Dennis, 183, Federal Reporter 2D 201, Ind Wiu Hill Belkins, 1967, 189, US 54, 57, referred to. Ryan's case, 1935, Irish Reports 170, Moore v. Sir. Attorney General for the LRI 1H Stat, 1935. AC 448, referred to Leonic v. the Queen, 1967, 1 AC 259, explained. Webb v. Outram, 1907, AC 81, PC, referred to. Alberta PRM case, 1938. 2 DLR 81, Sommier v. City, Quebec, 1953, 4 DLR 641. The Initiative and Referendum Act, 1919, AC 935, 945. AG Ontario v. G Canada, 1912, AC 571, Shannon v. Lower Mainland Dry Products Board, 1936, AC 708, Taylor v. Attorney General of QE Lund, 23 CLR 457, held inapplicable Mangal Singh v. Rao, Union of India, 1967 2 Sir 109, LCLD inapplicable,